Heather thinks about software.
This week, Google lost a patent judgment involving its Chromecast devices. This is a good opportunity to talk about how patent lawsuits work and why Google's stock did not drop after the news of this $338 million verdict, the size of which would probably have made most companies run for shelter of bankruptcy. The lawsuit was brought by Touchstream Technologies, based on its patents for streaming videos from one screen to another. I will link the actual patents and decision in the description. The invention described in the patents involves a system for presenting and controlling content on a display device. This case demonstrates a few important things about patent litigation, patent trolling, PTAB actions, and the weirdness of Texas. Touchstream is a non-practicing entity, otherwise known as a patent troll. That means it doesn't sell any products, it just sues for patent infringement. The U.S. law allows patent lawsuits even if the patent owner doesn't make any products. This rule has spawned a cottage industry of people sitting around thinking up ideas for products they could never actually make or sell, convincing the U.S. Patent Office to issue patents on them, waiting for real companies to make those products, and then suing them. Now, there are trolls and there are trolls. Some trolls are smash and grab trolls. These trolls threaten lots of lawsuits, usually via shoddily written complaints, and hope to settle for small amounts, say $50,000 to $100,000. They can do this because it costs a defendant that much to just answer a complaint in court, much less go through the whole litigation, which can cost millions. The other kind of troll is more dangerous. They have competent lawyers and better quality patents, and sometimes they win real lawsuits. But Google is well known for not rolling over to legal threats, and it is challenging the validity of the 3 asserted Touchstream patents at the PTAB, or Patent Trial and Appeal Board. A PTAB action allows a patent defendant to get a ruling that the patent is invalid, so it doesn't have to defend a patent infringement claim. About 50% of patents that are litigated end up being judged invalid. You might wonder how that can happen. Patents are examined by professional patent examiners before they issue, but the patent examiners only have access to so much information. Patent applicants are required to disclose all prior art on which the invention rests. For example, if you make a better mousetrap, you would have to mention what existing mousetraps were like and explain how yours improved on them. But applicants don't always disclose all their prior art. If an invention is obvious in light of prior art, then the patent is invalid. Showing obviousness is one of the main ways that patent defendants win both patent lawsuits and PTAB actions. The PTAB action was created in 2011 to address the flood of patent infringement lawsuits and to give patent defendants a way to challenge a patent before becoming a defendant in an infringement case. And often, when there is both a patent infringement lawsuit and a PTAB action pending, the patent infringement court delays its lawsuit until the PTAB action is done. That's because, often, judges don't like to hear cases whose outcome won't amount to anything due to other courts making their own decisions. But in this case, that didn't happen. That brings us to the last point, which is the weirdness of Texas. Patent lawsuits are always brought in federal courts because the patent law is the law of the U.S., not of individual states. But in a federal case, the plaintiff can choose where to file its lawsuit, at least anywhere the defendant does business. For a large company defendant that does business all over, that lawsuit could be brought against them anywhere in the U.S. So patent plaintiffs like to choose patent-friendly courts to file their claims. And you know what they say about Texas? It's friendly. At least, it's friendly to patents. In fact, it's so friendly that there is a town in Texas called Marshall whose main industry is patent litigation. That's right, the hotels and restaurants in Marshall cater almost exclusively to lawyers who have been hauled into court from out of town by patent plaintiffs. At one time, over 40% of all patent lawsuits in the United States were brought in the Eastern District, the so-called rocket docket. This problem was so bad that in 2019, Apple Computer closed its only stores in the Eastern District of Texas to avoid being sued there. Because who wants actual products when you can have a bunch of patent lawyers instead? But it gets worse. Marshall is in the Eastern District of Texas, but Waco, in the Western District of Texas, was missing out on the fun. So they started vying to be the most patent plaintiff-friendly district. One judge in particular, Judge Albright, a former patent lawyer, began taking most of the patent cases in the Western District, and his case management decisions were renowned as being very plaintiff favorable. That included things like accelerating cases and, wait for it, not staying cases when there were PTAB actions pending. In 2016 to 2017, the Waco division got 5 patent cases. In 2020, nearly 800 patent cases were filed there, more than 20% of all the cases filed in the U.S. This got so embarrassing to the legal community that in 2021, 2 senators, one Republican and one Democrat, wrote a joint letter criticizing the practices of the Western District. As a result, many cases were reassigned to other courts or other judges, and other districts, like Delaware, got a bigger share of the newly filed cases. All this shows how patent trolls and friendly judges can game the system and make a cottage industry that is a huge drain on innovation. It's a scandal. Personally, I think the patent system works well for lots of inventions that require significant R&D, like batteries and pharmaceuticals, many of which probably wouldn't exist but for the incentive of patent protection. But the patent system doesn't work as an incentive for someone to think, I wish I could watch that movie on my TV instead of my phone. That's more of an idle thought than an R&D project. For inventions like software methods and business methods, lots of people say the patent system is broken, and it's hard to disagree. And finally, why didn't Google stock tank on the news of its loss? Well, you never know why investors do what they do, but between the PTAB action and Google's ability to appeal the decision and the terrible reputation of Judge Albright and the Western District, chances may be good that Google will never pay any of that money. Liking and subscribing makes me think more.
Heather thinks about software.